The Supreme Court just dropped an 8-1 emergency order that completely changes how Second Amendment preservation fights will play out nationwide. And that lone dissenting opinion reveals exactly what's coming next. Make sure you're subscribed so you don't miss what happens next in this case. The 8-1. Order that nobody saw coming. The Supreme Court issued this emergency order with almost no advance warning. And the 8-1 split tells us something critical about where the justices stand on state power versus federal authority. 8 justices agreed on the core principle here, which means this isn't a partisan issue anymore. It's a constitutional consensus that crosses ideological lines. What makes this even more significant is that emergency orders typically get decided 5-4 or 6-3 on controversial issues. But an 8-1 vote signals that the legal reasoning here is so strong that justices who normally disagree found common ground. The court specifically addressed whether states can refuse to provide resources and personnel to federal agencies attempting to enforce laws the state considers unconstitutional. And they gave an answer that will echo through courtrooms across the country for decades. This order immediately affects how federal agents can operate in states with preservation laws, forcing them to rely entirely on federal resources without any state support or cooperation. But here's what most people missed in the initial headlines about this ruling. The court didn't just rule on the specific law in front of them. They actually created a 3-part test that every future preservation act will now be measured against. And understanding that test is the key to knowing which states will win and which will lose these battles. The 3-part test that changes everything. The Supreme Court laid out 3 specific criteria that state preservation laws must meet to survive constitutional challenges. And this is the roadmap that legislators in other states have been desperately waiting for. First, the law must clearly define which specific federal actions the state considers unconstitutional, rather than making broad, blanket statements about entire categories of federal law. Second, the law must restrict state assistance and cooperation, without actively obstructing or interfering with federal agents who are attempting to enforce federal law using their own resources. Third, the law must include a severability clause that allows constitutional portions to remain in effect even if specific provisions are struck down by courts. This 3-part framework means that roughly half of the existing preservation acts across the country will need to be rewritten to comply with these requirements or risk being invalidated entirely. States like Missouri, Montana, and Arizona that drafted their laws with vague language about all unconstitutional federal gun laws are now vulnerable to challenges they might have otherwise won. The justices made it clear that states have significant power to refuse cooperation, but that power must be exercised with precision and cannot cross the line into active interference with federal operations. It's what the test implicitly permits that has federal agencies quietly panicking about their ability to enforce regulations in red states going forward. What federal agencies can no longer count on. Federal enforcement of gun regulations has relied heavily on state cooperation for decades. And this ruling just severed that relationship in ways that will fundamentally alter how agencies like the ATF operate. Before this order, federal agents routinely used state crime databases, forensic laboratories, detention facilities, and local law enforcement manpower to execute their enforcement operations. A typical ATF investigation might involve a federal agent making a few calls to get state police assistance for surveillance, using county jail facilities to hold suspects, and accessing state ballistics databases to trace weapons. That entire cooperative framework is now optional for states, and many are choosing to opt out completely, which means federal agencies must now build parallel infrastructure in states that refuse cooperation. The ATF currently has approximately 2,600 agents nationwide to cover all 50 states, compared to over 800,000 state and local law enforcement officers they previously could coordinate with. Without state assistance, a single enforcement action that previously required 3 federal agents and a day of planning might now require 15 agents and a week of preparation. Some federal officials have privately admitted that certain enforcement priorities will simply become impossible in non-cooperative states due to resource constraints. Several states are taking this ruling as a green light to extend the same non-cooperation framework to other federal agencies, beyond just gun enforcement. And that's where this gets really interesting. If your state passed a law saying local police couldn't help federal agents enforce gun regulations you consider unconstitutional, would you support that law even if it made federal enforcement more difficult? The domino effect across other policy areas. This Supreme Court decision was about gun rights, but the constitutional principles involved apply equally to immigration enforcement, drug policy, environmental regulations, and tax collection. Arizona has already introduced legislation that would apply the same non-cooperation framework to immigration enforcement, specifically prohibiting state resources from being used to assist ICE operations that the state legislature hasn't explicitly authorized. California is considering similar legislation for environmental regulations, where the state would refuse to provide personnel or data to federal agencies enforcing rules that exceed California's own environmental standards. The anti-commandeering doctrine that formed the legal basis for this ruling was actually first established in immigration cases, not gun cases, which means courts will have difficulty distinguishing why it applies to Second Amendment issues, but not border enforcement. If states can refuse to help enforce federal gun laws on constitutional grounds, the same logic allows them to refuse help with federal immigration enforcement, federal drug scheduling, or federal land use policies. Constitutional law professors are already writing articles about how this could lead to dramatically different lived experiences of federal law depending on which state you reside in. The practical result is that federal law might remain technically supreme, but its actual enforcement becomes geographically inconsistent in unprecedented ways. What makes this particularly significant is the timing. This ruling comes at the exact moment when multiple states are actively expanding what they consider to be unconstitutional federal overreach, and the list of policies they're targeting goes way beyond guns. The lone dissent and what it reveals. Justice Sotomayor was the single dissenting voice in this 8-1 decision, and her dissent actually provides crucial insights into the boundaries of what states can and cannot do under this new framework. She agreed with the majority that states have anti-commandeering protections and cannot be forced to enforce federal law, but she argued that certain provisions in the state law crossed from non-cooperation into active obstruction. Her dissent focused specifically on penalties that the state law imposed on state officials who voluntarily chose to cooperate with federal agents, which she characterized as the state punishing its own employees for federal cooperation rather than simply declining to mandate it. This distinction matters because it reveals the exact line that future preservation acts cannot cross. States can refuse to order cooperation, but they cannot punish officers who choose to cooperate on their own time or with federal compensation. The dissent also raised concerns about provisions that would allow citizens to sue state officers for any cooperation with federal agents, arguing this creates a chilling effect that goes beyond simple non-cooperation. However, what's notable is that even in dissent, Sotomayor acknowledged that the core anti-commandeering principle is well established and that states have broad authority to decline participation in federal enforcement schemes. Legal analysts note that her dissent actually provides a blueprint for how to draft these laws in ways that even the most skeptical justice might accept. But what nobody's talking about is how states are already revising their laws based on her dissent to make them even stronger and more legally defensible. How states are responding with law revisions. Within 48 hours of this Supreme Court order being published, legislative drafters in at least 7 states began circulating revised Preservation Act language that addresses every concern raised in the dissent. The new model legislation removes penalty provisions for officers who cooperate on their own initiative, and instead focuses exclusively on prohibiting the state from directing, funding, or facilitating such cooperation through official channels. These revisions include explicit language stating that officers remain free to share information or provide assistance when acting in a personal capacity outside their official duties, and without using state resources. The updated laws also narrow the citizen lawsuit provisions to only apply when state officials use taxpayer resources or official authority to support federal enforcement, rather than applying to any cooperation whatsoever. Montana introduced a revised bill within 72 hours that Legislative Council believes eliminates every objection raised in Sotomayor's dissent, while maintaining all the protective effects of the original law. Oklahoma's Attorney General released a legal memo stating that their existing Preservation Act already complies with the framework established by this ruling and requires no modifications. What's particularly interesting is that blue states are now studying these revisions to see if similar frameworks could protect state marijuana legalization or sanctuary city policies from federal interference. The rate of legislative action here is unprecedented. Usually it takes months or years for states to respond to Supreme Court guidance, but we're seeing comprehensive rewrites happening in days. The speed of these revisions suggests that states had these bills already drafted and were just waiting for the court to show them where the constitutional boundaries are, and now they're moving fast before any new challenges can emerge. Do you think your state legislature is acting fast enough to protect your rights using this Supreme Court framework? Or are they missing the window of opportunity here? The practical enforcement crisis developing. Federal agencies are facing an enforcement crisis that goes beyond just needing more agents or bigger budgets. They're dealing with fundamental operational limitations that money alone cannot solve. When a federal agent needs to execute a search warrant in a non-cooperative state, they cannot simply call local police for backup, cannot use local forensics labs to process evidence, and cannot house arrested suspects in county jails. The federal government only operates detention facilities in 37 states, which means in the other 13 states, they must transport arrested individuals across state lines to the nearest federal facility, sometimes hundreds of miles away. This transportation requirement creates massive liability issues, requires additional agents to be pulled from other duties, and can result in delays that jeopardize time-sensitive investigations. Federal forensics labs are experiencing backlogs of 8 to 12 months in some regions, because they can no longer send evidence to state labs that process results in 2 to 3 weeks. Some federal prosecutors have privately indicated that they're declining to pursue certain cases in non-cooperative states, because the resource investment required makes prosecution impractical, even when they have strong evidence. The ATF recently closed 2 regional offices in states with preservation acts, because the offices could no longer function effectively without state cooperation, and weren't producing enough cases to justify the overhead costs. Environmental Protection Agency enforcement actions in non-cooperative states have fallen by 65%, according to internal agency data that was leaked to the press last month. But the federal government isn't taking this lying down. They're developing workaround strategies that could actually make their enforcement more aggressive in certain ways, not less. Federal workarounds and escalation tactics. Federal agencies are adapting to this new reality by developing enforcement strategies that rely less on state cooperation and more on direct federal action. And some of these tactics are more aggressive than what they used when they had state partnerships. The ATF is hiring retired state and local law enforcement officers as federal contractors to provide the local knowledge and relationships that current state employees can no longer officially provide. The FBI is expanding its Joint Terrorism Task Force model to gun enforcement by creating financial incentives for individual state officers to participate on federal task forces, where they report to federal supervisors rather than state command. Federal agencies are also increasing their use of administrative subpoenas and civil enforcement actions that don't require search warrants or arrest operations where they previously would have pursued criminal cases. The Justice Department is bringing more civil rights lawsuits against states themselves rather than prosecuting individuals, shifting from criminal enforcement to constitutional litigation as their primary tool. In states where they cannot access state databases, federal agencies are purchasing similar data from private sector vendors who aggregate information from public records and commercial sources. The DEA has started paying informants significantly higher amounts in non-cooperative states to compensate for the lack of official intelligence sharing from state law enforcement. These workarounds are costing substantially more than the previous cooperative model. But federal officials argue that maintaining enforcement presence in every state is worth the additional expense. What's really concerning is how these workarounds are creating a two-tier system where federal enforcement looks completely different depending on whether your state cooperates, and that's raising some serious equal protection questions. The constitutional questions nobody's asking yet. This ruling solves the immediate question about state cooperation, but it creates a dozen new constitutional problems that will need to be resolved in future cases. If federal law is supposed to be supreme and uniform across all states, how can we justify a system where it's vigorously enforced in California, but barely enforced in Wyoming due to resource limitations? The Equal Protection Clause arguably requires that federal law be applied consistently to all citizens regardless of which state they live in. But this ruling makes geographic enforcement disparities inevitable. There's also the question of whether states can use their non-cooperation as leverage to negotiate with federal agencies about how laws will be enforced within their borders, essentially creating informal federalism agreements. Some legal scholars argue that if states can refuse cooperation on laws they consider unconstitutional, they're effectively exercising a form of nullification that the Supreme Court supposedly rejected after the Civil War. The counter-argument is that there's a fundamental difference between a state declaring a federal law void and a state simply declining to enforce it. But that distinction becomes blurry in practice when non-enforcement makes the law effectively void within that state's borders. Another emerging issue is whether Congress can condition federal funding on state cooperation with enforcement, essentially buying compliance, even if they can't commandeer it. There are also international law implications, since the United States has treaty obligations for certain enforcement actions, and state non-cooperation could put the country in breach of those treaties. The biggest question that this ruling leaves completely unanswered is what happens when the political parties controlling the federal government and state governments flip, because the states celebrating this decision today might be the ones fighting against it tomorrow. If the federal government controlled by the party you oppose passes a law you think is unconstitutional, should your state have the power to refuse enforcement, even if that means the law effectively doesn't apply in your state? This Supreme Court order is just the beginning of a much larger constitutional battle that will reshape federalism for generations. Make sure you're subscribed and hit the notification bell so you catch every update as this case develops. Because what happens next will directly impact your rights, regardless of which state you call home.